Okay. Actually, here the petition. The Gram Panchayat clerkship. And some more especially from schedule area.
Why public notice? This is a requirement under the law.
Section 27 also.
So
27.
why you wanted to quash it?
Not particular.
You are you are quashing the public notice dated 17/1. You have paid for. So your first prayer A.
Lordship, I have put that in the same such thing, requesting Lordship. It is not required under law, Lordship.
No. Why?
We are opposing to the said notice, Lordship, because this opening is continuous, Lordship. The renewal is continuous.
You are saying that
Objection.
You are saying that it is after the allotment, you are the public hearing.
Lordship.
no, it is scheduled area.
Lordship.
You are saying that it is scheduled area. Gram Sabha has decided not to
Not to, Lordship.
install or establish, allow establishment of any liquor shop.
Legal shop, Lordship. And it is said,
So that is taken as a resolution.
resolution,
Now they are bringing out, they have allotted one of the persons
Lordship.
to carry on with the shop.
Lordship.
That is your project.
And also since
No.
1993,
Let me understand the rule. What is the
section 27, Lordship.
these excise rules?
What is that? Excise Act 27, Lordship, section 27.
So you are coming under the scheduled area. So there is a complete embargo that it cannot be done
Without Lordship consent of the Gram Panchayat.
without the approval of the concerned Gram Panchayat. Yes, have you obtained the consent of a Gram Panchayat with concurrence of the Gram Sasan?
Sabha.
No. Gram Panchayat, Gram Sasan.
Gram Sabha has taken a conscious decision.
Because I am aware of the word Sansad, Gram Sansad.
Here, Lordship.
There the word is Gram Sansad and Gram Sabha.
Sabha. But the Pesar and Lordship, all those.
Oh, it is already a running shop.
Lordship, since 1993 we are opposing, Lordship. Since 1993 the Gram Sabha, Lordship, the Panchayat is opposing this.
But they were operating there.
Lordship, renewal is, Lordship, because of the fact that it should not come, Lordship, because they should close down the entire shop. Reason being, Lordship, the Gram
No,
Panchayat.
it was done with the concurrence of a Gram Sabha and Gram
No,
Sasan.
Lordship, can you see where?
They are saying,
No, Lordship,
they are saying the approval.
Lordship, can you see annexure 2?
After the resolution was submitted on 18th February, inquiry was conducted on 23rd March.
Sabha's resolution. That inspector of excise has.
Now, as the inquiry report and the other documents will be placed
Is
before.
it not coming within the scheduled area? Is it not coming within the scheduled area?
It is coming, minus public notice.
Are you disputing that it is not coming within the scheduled area or it is scheduled area?
It is.
If it is scheduled area, then complete embargo under the statute.
Minus.
Then where is the scope?
Yes, sir. So once the resolution was submitted, an inquiry was conducted into that said.
No, madam. The rule is very clear. It says that in a scheduled area, no license can be granted unless the Gram Panchayat gives approval with concurrence of Gram Sasan. Now, these two conditions have to be fulfilled.
Yes, my
If
lords.
there is an objection by a Gram Panchayat or a Gram Sasan, then in that event, how can you give? Because the language is negative.
This report along with the resolution would be placed before the collector, my lords, after the.
Sir, there is already a resolution of a Gram Panchayat which is taken on 18-2. They wanted that there should not be any approval to be granted. If there is already objection, then there is no question of any public hearing to be undertaken. It is
the
there.
report also regarding the meeting, also the meeting which was conducted by the Gram Sabha, that was not as per the rules of Gram Panchayat rules, my lords. It's also included in the inquiry report. If the lordships may see.
What has not been done?
My lords, the meeting which was called to pass the resolution for objection of the opening of the old shop, my lords, resolution, that meeting was not conducted as per the requisite rules, my lords.
Sir, it can only be granted on the approval if they have raised an objection. Then the public hearing is for what? Just to hear out.
Such has been granted yet. It's pending for collector's consideration, my lords. After this inquiry was conducted, now in the last.
Madam, probably I am not connecting the frequency of the mind with you. What I understood is the rule 27 is very clear that if it is coming within the scheduled area, a complete embargo is created that there should not be granted any license either for manufacturing, possession or a sale of a liquor without the prior approval of the concerned Gram Panchayat in concurrence with the Gram Sasan. So there are twin conditions. Prior approval of a Gram Panchayat. Now, when you talk about a public hearing, what is meant by the public hearing? Means the public should be heard. Since all cannot be heard together, they have a representation under the Panchayati Raj. So they represent the collective wisdom or the decision of the villagers. If they have taken a resolution that yes, we have an objection, now putting a clock, taking shelter under the intricacies of the law, is it really whether it serves the purpose? Who are you to create it? It's a wisdom or a collective wisdom of the villagers.
Well, it's regarding that, my lords, if your lordships may kindly see the last page of the report, my lords. Last page, if your lordship may kindly see, there is another petition, that page, my lords.
What?
Page 5.
Yes, what?
That the surgically OS shop is functioning since last 25 years with prior approval and no objection has been made. But at the fat end of the tenure, the Sarpanch and the
I am asking you, madam, I understand. Suppose.
Thereafter, my lords,
Yes.
fourth para, my lords, in another application, some villages have stated that Shri Deepak Pandey with some other people have taken the signatures of public moving from door to door, asking, they stated that they are taking signatures for purpose of old age pension and house scheme of GP. They do not know about the closure of the OS shop.
No, she is not understanding where our obstacles are.
Yes.
Madam, then one query. Is it whether it is a mandate under the rules to undertake the fresh exercise of the approval and the concurrence before renewing the license?
No, Max, regarding
I'm asking you very simple question. If those have to be followed, it is immaterial that at one point of time there was no objection. But at this point of time, there may be an objection. Only again saying, for the purpose of the renewal, is it the mandate of the rules to get a fresh approval or no fresh approval is required. If it is not required, once given, it is perennial in nature, no problem, madam. But if it is required, then every time a fresh approval is to be obtained. What is the law?
At the time of grant of that exclusive privilege,
Renewal is automatic. You will not entertain any kind of objection subsequent thereto. Why take it in this way?
Yes, ma'am.
Take it. Why you issued a public hearing notice? There was no requirement. If you say there is no further requirement, why you have issued a public notice, madam?
Well, it's in section 27 of subclause 2. It says that for the purpose of clause A of subsection 1, the authority competent to grant license for manufacture, possession, sale, or exclusive privilege of manufacture or sale of any intoxicant shall, before granting such license or exclusive privilege, refer every proposal therefore to the concerned Gram Panchayat for its decision within a period of 30 days
Correct.
from the date of receipt of such reference.
No difficulty, madam.
And if the Gram Panchayat fails to communicate its decision,
Deemed approval. I'm again, that means then the requirement is that for every grant of a license, be it a renewal or be it a fresh, the concurrence of the Gram Panchayat is required. Correct.
scheduled in.
If the Gram Panchayat has raised an objection, whether the action of or a stand of the authority that this resolution is not strictly in terms of several provision of the Gram Panchayat Act, permissible,
Well, it's
appreciable.
yes, Manas, but what I'm this has the collector has not yet gotten the opportunity to consider that resolution. Manas, that has been placed before the collector, which we have included at the end of our instruction also. That the report and the resolution will be placed.
Madam,
before
then
the
I
collector.
do not find from this section that once an objection is raised, the matter would be placed before the authority who can overrule the objection and take his own decision. Is there any provision
No, Manas,
that the
objection-
supremacy of the officer is there?
Any decision will be passed in compliance with the statutory provisions. Further, Malas, under section 41 of the Odisha Excise Act, no objection shall be entertained for shops which is continuing in an area for more than 3 years.
Where is that? Show us.
Malas, under section 41 of the Odisha
Yes,
Excise
you
Act.
show us that law. I am asking for this law to come,
Yes, ma'am.
please.
After, may I read, Malas?
Yes.
After the date prescribed for receipt of objections and suggestions, the collector shall consider the objection suggestions submitted under section 40 and if necessary revise the said list and shall decide for which places license for the retail sellers shall be granted,
Correct.
provided that no objection shall ordinarily be entertained for shops continuing in an area for more than 3 years unless there are special reasons to be recorded in writing.
Correct.
So, Manas, this shop has been continuing for more than 3 years. And it's close to
So
20.
special reason is
So,
low cost.
Manas?
Special reason is low cost,
No, Manas.
reasonable cost.
And also, this is an area prone to ID cases, Manas. So,
What she's saying.
2017. The second provision, Manas. Second provision provided further that in the scheduled areas, no such license or exclusive privilege shall be granted without giving 30 days time as required under section 27. Now, this has to be read with rule 33, Manas. Rule 33 says that all objections and suggestions referred to in Rule 31 with respect to proposals contained in the list prepared under Rule 30 shall be sent to the collector within 15 days from the date of expiry of the period of notice, and in case of cantonment, the commanding officer. So, my lords, here the proposal has been sent to the collector.
What is the cumulative effect of these provisions?
Yes.
In a general sense, where the license is granted beyond the scheduled area, then section 30 and second proviso, the other provisos will apply. But once the second proviso is restricted to a scheduled area,
Yes.
and it says that without
Yes.
having the objection being considered, it cannot be granted.
Yes.
Then it creates a carved out an exception from the general rule, and that would be considered as the standalone premises of that. How can you generalize 33? That is a very common general. And how can you apply section 41? Sorry, section, you said, section, yes, 41.
It's still not what I'm submitting, minus that since no decision as such has been taken yet by the collector.
Madam, probably we are going at the route
Yes.
when you are undertaking an exercise of a notice or a public notice, 3 and 7 of rule 3, I do not know, sub rule 3 and 7 of rule 3 of the Orissa Panchayat rules. Okay. Is it proper for the officer to make this technical plea? That shows that you are banking upon doing something or doing something when there is a public objection.
No, man, it's just since the objections were received, it was considered prudent to conduct an inquiry so as to ensure that the veracity of those resolutions matters, and then the same would be placed before the collector, which then might reject or accept as per the. But then, if your lordships consider appropriate,
Better not to. Brother.
to consider those objections.
We are the Gram Panchayat, Lordship.
Gram Panchayat is a conglomeration of the villagers.
Lordship.
Why you have not included the villagers?
Lordship, they have represented me to approach.
I am asking you whether it is a juristic person.
Lordship, in fact, Lordship, by way of
I am
resolution,
asking the panchayat is a juristic person.
because the Lordship law says the language is Gram.
Or by a common seal and this. Under many act like a society registration act says that the society itself is a character of a juristic person. I'm asking.
The Gram Panchayat,
They have included
Lordship.
that Gram Panchayat means all the total voters of the said Gram.
Lordship, that is, Lordship, kindly,
That is what it
Lordship,
says. They talk about it that they include everybody.
Lordship, kindly come to Gram Panchayat for a moment, Lordship. Section 11, Lordship, kindly. Section 10 for up, Lordship. Section 10. And Lord, section 10, section 10 is the constitutional, Lordship.
Please,
Section 10,
I'm asking whether particular subsection or what? What is the character?
Lordship.
That is the composition of the Gram
Gram
Panchayat. What is
Panchayat.
the status of the Gram?
Lordship, it is the constitutional body, Lordship.
I'm asking
Lordship.
where?
Lordship, it is under Article 243, Lordship, kindly see it is a constitutional, Lordship. Constitutional body. Article 243, Lordship, kindly see it is a constitutional body.
No, I'm talking about section 7 in that sense.
Yes.
I was looking at. Panchayat is not, but Gram Sasan is. Look at section 3 and 4, the distinction. Can you give a book?
कितने वॉल्यूम से
Please give my book.
आई एम गिविंग
Please give my book. You will share it.
वी हैव एन
Please give.
Yes.
Please look at 3. I think the Gram Panchayat is defined in section 2
Lordship.
as Grama means constituted under 3.
Lordship.
Please look at the 3.
Constitution of Gram, Lordship.
Sorry.
The state government may, for the purpose of the act by declaration notified in the Gazette, constitute any village or group of a contiguous villages as Gram and assign to such Gram a name which shall be of the villages comprised with the Gram.
So,
It is
what is explanation?
excellent. Village
That is a
intervened
first, forget about it. Then come to first proviso.
Lordship, provided that in the scheduled areas, a gram shall ordinarily consist of a habitation or group of habitations, a hamlet or group of hamlets comprising a community or communities and managing its affairs in accordance with the traditions and customs system.
There are 2.
Whenever the state government deemed fit to do so,
So he can add. So the Gram Panchayat does not appear to be
a body corporate or a standalone or entity come to 4 Gram Sastra. We find a distinction.
Constitution and incorporation of gram session.
Whatever.
For every gram, there can be a gram session which shall be composed of all persons.
Which shall be composed of
Composed of all persons.
persons.
All persons registered by the virtue of representation of people of
That is
1950.
the electoral roll.
Role.
Yes, then
In so much of the electoral roll of any assembly constituency for the time being in force as relates to the gram, then lordship on the roll shall be deemed to be the electoral roll in the respect of
to
the gram session shall be a body of corporate. Lordship,
body of corporate, no, body corporate.
body corporate by the name that's sorry, lordship. That's them.
Correct.
Correct.
And then by the name of a gram
Lordship.
to which it relates, having perpetual succession. That is what I was asking, is there any? And common seal.
Common seal, lordship. That
So Gram Sasan alone is a legal entity,
That
as
is-
a body corporate.
lordship.
Gram Panchayat.
That is gram panchayat, lordship.
No, sir.
Gram
Gram Sas, when the section 27 make 2 distinctions.
lordship.
That Gram Panchayat and Gram Sasan are 2 different or distinct or a unit or entity and defined differently, then why is section 27 what it says?
Lordship, can you come to article?
Please, I am asking you.
Everything defined.
Now I am asking you,
Lordship.
27 says
Lordship.
what? Except with the prior approval of the concerned Gram Panchayat,
Lordship.
accorded with the concurrence of Gram Sasan. So, if 2 separate entities approval is required, then they are 2 distinct entities.
No,
Not you
I
can't
can,
let it.
clarify, lordship, but still, lordship.
Huh? No, no, say 7 is a proposition.
Lordship.
Yes.
Of the gram session.
As a gram
Body corporate.
Seven, my brother has also
Lordship.
very wrongly worded,
Lordship, can you come
very
to
badly
constitution?
worded, I tell you.
Lordship, article 243, lordship will give
There is
entire
a
picture, lordship.
Panchayati Raj. You
Yes, lordship, article 243. Every definition has been, lordship.
No, there should be a Gram Panchayati Raj was introduced.
No, lordship. The area has been defined there, lordship.
Oh, area, I understand. Please kindly consider.
Lordship.
When a Gram Panchayat comes as a legal entity, I am again saying
Yes.
whether it is a juristic person
Juristic persons.
or a legal entity
Legal entity, lordship.
capable of
Yes, lordship.
espousing the cause in
Yes.
such capacity.
Yes, lordship. Can you come to article 243, lordship?
Yes. 43A, B, C.
Only 243, lordship,
Yes.
chapter 9, the definition chapter I'm reading, lordship.
Yes.
Lordship, kindly see, first they have defined district. District means the district in the state.
What? 243.
243, lordship.
No. District means a district of the state.
Lordship.
Come to a Gram
Gram
Sabha.
Sabha, then lordship, Gram Sabha. Lordship, Gram Sabha means a body consisting of persons registered in the electoral rolls relating to village comprised with the area panchayat at the village level.
That's the definition.
I'm coming, lordship. Then lordship, kindly come
Panchayat.
panchayat.
Yes, I know. I
Panchayat
read
means
it.
an institution
Self-government.
of lordship. Then lordship panchayat area.
Yes.
Means the
There is-
territory
that
of
is also provided
panchayat
in
means
the
it consists of this grams, lordship.
I understand that is what the spirit of the rules are.
Lordship.
I am not saying at one, but as a legal entity, a Gram Panchayat is coming.
Lordship.
Whether it can institute a suit, it can institute a legal proceeding is the first question.
Lordship.
Whether it's a conglomeration of several persons, then it is in a representative capacity, then how? Then why not order 1 rule 8 will apply like a representative suit?
Lordship,
Here
here,
will have to take a lead.
yes, Lordship, kindly see, then come to Lordship, the Gram Sabha, 243A.
Just for.
Just I am understanding.
Lordship.
in 243.
Lordship,
Again,
again, let me read it.
then I have read it, then what do you want?
Lordship,
It is the organization of a perpetual succession or a common seal or a body corporate, like a Gram Sasad. If it is not, then whether it can sue or be sued in its own capacity, that is what is the main fundamental question.
that has already been tested by this honorable court, Lordship.
Sure,
So,
sir.
Lordship, that I have not brought the judgment, Lordship, that has already been tested.
Sure.
Lordship, again, I'm reading, Lordship, kindly come to Gram Sabha once again, I'm reading, Lordship. Then I'll come to composition of Gram Panchayat, Lordship. Thus, there shall be constituted in every state panchayats at the village, intermediate and district levels in accordance with the provisions of this part, notwithstanding anything in clause 1. Panchayats at the intermediate level may not be considered in a state having a population not exceeding 20 lakhs. Then 243C, composition of panchayats. Subject to provisions of this part, the legislature of the state may by law make provisions with respect to the composition of panchayats.
Sir, probably I am not able to connect the wavelength of the mind.
I'm sorry, Lordship,
But what I am not saying what should be the composition. There is a lack of composition, defect in composition. I am not.
Lordship.
A Gram Panchayat as a juristic person or as a legal entity has approached the court. The first question is whether it is a juristic person or a legal entity.
Lordship.
First question. If it is not, then whether it can sue or be sued in such capacity. I am simply asking this question. It's a pure civil concept which I am asking in a constitutional
It
jurisdiction.
is legal entity because, Lordship,
Where? Because you see Gram Sasan,
Lordship.
it is a body corporate. It's a legal entity, juristic person. Why not it is given to a Gram Panchayat in a similar fashion? Why? Why the legislatures have consciously omitted this particular thing in relation to a Gram Panchayat when it is given in relation to a Gram Sasana? Both are distinct.
But that has been tested in Lordship issue.
Show us the judgment we are ready to accept.
In fact,
We have two options. Ready to accept if the reasons appears to be very sound, logical, in tune with the law, or we have a reason to dissent if we have the different notions.
but this is already
Section 7, if you read,
Lordship.
that says about panchayat.
Lordship.
Panchayat status it has given. It has no perpetual succession, it has given. It is only executive authority of Gram Sasan. So Gram Sasan being the legal entity or juristic person,
Body corporate.
body person.
Yes.
So it is only executive authority. Panchayat. Under you see, 7.
Lordship, I have already
Read, sir.
Lordship, there shall be a, for every Gram Sasana, a Gram Panchayat as herein after. Constitute which shall be the executive authority of Gram Sasana. That is there.
So that there make a distinction whether the Gram Panchayat independently initiate a proceeding.
Now come to definition.
Lordship.
2, G, H and J. The distinct constitution under particulars.
Mr. Sahu, what is your reaction?
My reaction, I was just going through a Punjab Haryana judgment. It says that so far as panchayat is concerned, it can sue and be sued. But when property vests with the panchayat, here property
It's not
is
a question of
vested.
property.
Here panchayat is protecting the interest of the public grounds.
In relation to Article 300 capital A, if the property has waste, then definitely it becomes the holder of the property and he can sue and be sued in
Correct.
But the here is a question is different.
It's espousing the cause of the public. That is how panchayat gets represented for public.
Our definitions are something.
And because the Gram Sasan has been considered as a body
Corporate, yes, your lordship rightly says.
different.
Body corporate.
It's a body corporate. It says
Body corporate.
Ram Sasan is a body corporate having a perpetual succession.
Like company,
Like a
concept of company.
incorporated.
Council,
True. It's
Yeah.
coming under as a corporation.
The executives may come and go,
correct.
but Sasam remains.
It will remain.
So, yes.
Whereas Panchayat does. It is only executive work.
It made it more.
That also says better lordship.
No, cannot be, because it is definitions. Section,
But that is
section,
tested lordship as per my,
Shows-
by this honorable court.
shows-
And lordship.
maybe,
There may be, I do not know, in Punjab, there may be a decision, the section is like that. Will be a body corporate having a perpetual succession.
Punjab Haryana has also
Keen to do it.
there is no distinction between Sasran and
If
Panchayat.
there is, find out that particular, the provision.
and Mr.
Panchayat Act something Punjab.
We have held that Sarpanch has.
Sarpanch lordship, no. But Gram Panchayat lordship.
Gram Panchayat represented.
Gram Panchayat lordship. We have filed thousands of writ applications. Thousands of writ applications should file.
Maybe.
Not also
I think there will
100.
be
And
one-
my office lordship.
there will be a one incidence
Lordship.
out of lakhs, which can be an eye opener.
But let's say my case has gone up to Supreme Court lordship. Supreme Court also given the same thing.
This question might not have raised.
103 Gram Panchayat lordship we had.
Question might not have raised that.
That has been tested and lordship, that matter has been remanded to this. Again, one second.
Find out that particular provision if there. What is the provision?
Section 5 and 6. Section 5 deals with establishment and constitution of Gram Sabha. So that says that every Gram Sabha shall by name notified under subsection 1 be a body corporate having perpetual succession and a common seal and subject to any restriction by or under this act.
No difficult.
Yes.
What is the Gram Sasana? Same. And Panchayat,
Panchayat is section 6. Every Sabha shall in the prescribed manner elect from amongst its members a chairman of the Sabha and an executive committee consisting of such number of persons not being less than 5 or more than 9, including in the Sarpanch of the executive committee as the government may determine, taking into account the population of the Sabha area.
the institution was by a Sabha or a Panchayat there in that case, Punjab.
The question then was whether Gram Sabha or Gram Panchayat is liable to be sued or to institute a suit. That was the
What
question.
was the, so far as Panchayat is concerned, is there any provision?
Ultimately, they say can be sued or sued.
Here, section 5 is something different. Section 5, Gram Sabha and its functions. Gram Sabha is not body corporate. Here only, there shall be at least 2 meetings. And Gram Sabha is only a Sabha.
Later on, there was a new section 8 that was inserted, that is incorporation of Gram Panchayat. Every Gram Panchayat shall by the name notified under subsection 1 of section 5 be a body corporate having
So that's
perpetual.
why it says, I am also at one. If it is a body corporate, no problem.
Yes,
Ram Sashan can come.
Yes,
I was really having that problem when you said so, then I was having some kind of a mind because that section must be there. Recognizing a particular, the entity as a body corporate, perpetual succession, common seal. These are the 3
Correct.
magical words which must come. Perpetual succession and the body corporate. Mr. Duloy,
But let's say
enlighten us.
this court has already lordship.
We cannot remain in a dark cloud for all times to
That
come.
has already been tested lordship. So for my knowledge,
If you say there is a silver line in the dark cloud, show us that line. He was a young lawyer. He did a wonderful work. So that's why I was skeptical. Then I asked, look at the provision there. The provision is very clear. Tell me when you can cite a judge. Mr. Duloy,
lordship I can, but lordship,
when?
act remains lordship 31st it lordship the.
Tell me, RTA.
No,
On 30th, we are ready.
I'm not, that's it.
You will not be available.
Yes.
You can join virtual for that purpose. Wherever you be.
No, Mr. Dulai, I tell you any of them. Just give that judgment. If we find there is no reason.
In fact, Lordship, today I'm leaving Lordship, so that's why.
Oh,
So that's why.
Independent view, but my view as of now is to.
And this issue, I say this issue was before this Honorable Court.
What I wanted.
Yes, that's it. I can.
Give it at 12, you can give it at 1. There's no difficult reason, we'll take it. We'll take it, but I believe that every judgment is.
What I prayed for Lordship, let it be on Lordship 7th or 8th Lordship. In the meantime, Lordship.
That is the problem, that is what is the problem with me.
But Lordship,
If I am not convinced,
if Lordship, they will.
it's very difficult to have the interim order, sir. You have been watching me at least since last 1 year.
Yes.
I can share on a day of an anniversary, assuming office 8. Interesting point you raised.
Lordship.
Item number 2.
May I please? Yes, it's an application with a prayer for modification. But what has happened? There is an erroneous. Recording of erroneous fact. That is what required.
If there is a finding of the appellate authority which is being taken care of in that order, you have already challenged that order of the appellate authority.
Before the tribunal.
The matter is still sub judice.
Exactly, Josh.
The law is very clear
Correct, Mills.
that the finding remains operative and binding on you unless set aside or upset by a higher court.
Correct.
So that finding cannot be said to be a perverse finding and to be deleted or to be taken off from the record.
And that one line your worship always will say, your worship's observation will not influence.
Correct.
That it has not been said, but your worship always says one, your worship can add one sentence. I am not on that. Apart from that your worship, I will pray your worship do. Because in all cases, your worship says so. Any observation made,
Because definitely it is a extreme order, it is tentative in nature.
yes,
It is not
that will influence the pending appellate authority, so that will impact. But only what I am cannot agree is a erroneous finding. It happens with us. Infallibility always there, human error is there. The Lordship in that this has occurred with us. My Lord's order is correct with us. Except that, only one thing I will point out to Lordship's below. not the appellate order, but this coordinate bench of this honorable order has not been rightly reflected.
Where?
My lordship, kindly see paragraph 3.1 of your lordship's order, Bills. The last line, notwithstanding that, if your lordship permit from the beginning, I will place below. 3.1, it is further submitted that the commissioner had ordered
Yeah,
the
1 minute, 3 point.
3.1 years.
Yes.
It is further submitted that the commissioner had ordered dated 16 February 2026 without appreciating the fact of submission of statutory declaration to Form C covering interstate sales to the extent of 240 crores so and so before the assessing authority in proper perspective. And she did not show inclination to grant stay of realization of balance demand amount during pendency of second appeal before the Orissa Sales Tax Tribunal. Notwithstanding that, the dealer has deposited 20% of the demanded tax during the pendency of the first appeal in terms of subsection 4 of section 16 of the OET Act. But this is to be clarified by adding, this is not only in terms of section 16.4, but in terms of whereas order passed by this Honorable Court dated 16/4/24 in WPC number 1974/16 grounds. That's what your lordship have said. My lordship kindly see.
Is it appearing from the beginning?
Yes, Vilas. That your lordship will
That you
find.
have deposited in 20% in terms.
Yes.
What are past.
Correct.
Another, where do I get it?
Yes. Just I am taking your lordship's address to that your lordship will find.
Well,
First of all, the paragraph 5 of my lord's order will write. Two paragraphs I have. Page 74. Page 74, Vilas.
of the repetition.
Yes, for petition. Matter of record, Vilas.
No, I understand.
My lords. Otherwise, I won't have trouble, my lords. I understand. We are paragraph 5 of my lords, or coordinate bench order, we are paragraph 5. Accordingly, while to refrain from exercising the jurisdiction over this matter, grant liberty to the petitioner to file an appeal within a period of 1 week from today, along with the necessary pre-deposit. After deducting therefrom the turnover relatable to the declaration forms now which will be produced by him before the first appeal authority, and the said calculations are verified by the first appeal authority and subject to any further direction passed with regard to the pre-deposit. Now, page 77.
At the time of appeal.
Exactly, Lord. 16 book, 16 book.
First appeal.
Correct, 16. Right.
This declaration forms were not taken into, they were not allowed by the first appeal authority.
That is,
So this is why.
that is very sorry. Just kindly bear it here.
Second thing is whether this direction is not surpluses or superfluous.
Whereas,
If the court thinks that I will not exercise the jurisdiction, can it pass a further order? Is it not exercise of the jurisdiction?
whereas once your
I'm
lordship,
asking Mr. Sao, is
My
a
lord.
pertinent question.
whereas once your
I'm
lordship,
asking,
my lord,
first line says that I refrain from exercising my
Correct,
jurisdiction.
my lord. my lord,
Then it should have stopped.
my lord,
It should not have moved further.
my lord.
And if it moved further, then you have exercised the jurisdiction.
Whereas even the erroneous order of my lords is also binding on the subordinate authority.
Anyhow,
That-
so where is this two question of any 20% deposit in terms of.
Exactly, page 77, Vilas. Page 77. Page 77, you are kindly. Pursuant to the direction of the Honorable High Court, the petitioner preferred appeal before the Joint Commission of Sales Tax, Balester Range on 23/4/24 with pre-deposit of 3,50,143 and thereafter the same has been assigned to this forum for adjudication. As per the direction of the Honorable High Court, the appellant has also deposited a sum of rupees 3,50,143. Now you will also kind. The calculation of the amount of pre-deposit made by the appellant placed in the record, which are verified and found to be in order, the appeal is admitted. So therefore,
Because of that finding of this,
correct, Lord.
but simultaneously you say that first appellate authority has not admitted or accepted or allowed your declaration forms.
No, I am not saying, he has verified.
Then we are saying, since that finding of fact by the appellate authority, having not accepted your or allowed your declaration forms, so what remains? The demanded tax remains. So, over and above 20%.
There are two things here.
30% to it.
That is a consequence. I have not done that. Because I am only at the stage of
No, you can't say 20% deposit, we say in terms of subsection 4 or section 16.
Correct.
You wanted that it should also be treated as a deposit in terms of that order in the separate provision. I really think that it hardly makes any changes. It hardly makes any differences. I understand that in the event the appeal is allowed, what would be the consequences? You would really wanted to have that in your mind. But I don't think so. There will be any. If it is fast and it's fast for all time.
20% amounts to 50 lakhs.
51 lakhs.
51 lakhs. But what I am saying, but your lordship's order is correct, except that only one line you added below. But I am not agreeable. Even though I have made a prayer to reduce from 30% to 20%, but that is our prayer. For grounds belots, para G belots, ground number, page 17.
Mr. Sahu, then you are attempting to have the review of the judgment on a limited scope in the guise of a modification and clarification. No. It's not permissible. No, you say erroneous finding. This is not a correct finding. There's an error which is incorrect. Modification when you want it. It is really a review which you want to achieve. No. I will never that this is what the error has been committed. We can appreciate only one aspect. We can say at the last, adding a line that since we have considered only the writ petitions in a limited ground, the appeal before the tribunal is pending, which will obviously be decided by on the basis of the merit. So this observation may not stand in the way. Independently they will exercise that. That's all.
And let me know how much have you said, what I'm saying.
Which is the order of the law also. That's all.
So only little clarification I want, belots. But as your lordship says, belots, your lordship has authored the judgment, belots. I am just asking, belots. But only simple, I don't quarrel with anything, belots. The rule says, but I am ready to pay 20%, belots. Or 30% your lordship is saying, but your lordship is kind direct, I let me deposit. But this, unless this is clarified, belots, 30% lordship direct, belots. I will ask my client to pay any cost, let him pay, belots. Only that much your lordship said. Because otherwise, if two things subsist, belots, then it will have a different implication.
No.
You also kindly see, if first and second both subsist.
Second appeal, your first appeal is disposed of.
So disposed of.
So
Your first appeal is disposed of.
Correct.
Second appeal.
Minus.
tribunal will decide
So
independently.
that finding of fact is staring at us.
Correct.
So how can we tinker with that finding?
I only want to tell my lords, let me not at fault. Because your lordship has said, I have deposited 20%. Yes, I have deposited 20%, but I have complied with your lordship's order and paid 20%. That's for clarification. Well, I am not.
So it cannot be considered as an admission or a waiver of your right which you are apprehending. Sir, if you comply an order of the court, that means the compliance is in that regard. But it does not mean that your points of your contentions has been foreclosed. It is by way of an interim arrangement, this is what is to be done. We could have interfered with the appellate order. We could have interfered and
I cannot
saying that 20% is the the demand which can be raised by them. We could have foreclosed that loan. But we have not, because the authority has to decide it. That means it is really an interim arrangement, so that the authority will decide the matter, and the revenues interest is also to be taken care of. It is really bringing a balance between the SSC and the revenue, so they may not suffer. So that is what is there. Why you are perceiving everything to be a minus one?
Yes, so may I understand, just for my clarification, small thing, but I am also not quarreling. Your lordship will, because the other day, once your lordship said how much you will pay, we also know how to refrain ourselves from arguing much more. Because I could have showed your lordship how the record. Submitting the literally understood because now out of the total tax demand because the amount which I have paid for admission of appeal towards complying 16(4).
Sir, this also I have observed in paragraph 7.
Paragraph 7, yes, madam.
You see, I have also, we have done,
Madam.
except saying that commission of sales tax on appreciating pre-deposit made by different dealers as per swearing.
Yes.
The first appeal granted stay of realization of balance demanded tax. Nothing is argued as to why the petitioner did not defaulted in producing the relevant material before the auditing the assessing authority and the arbiter. This court is conscious of the fact that the interim orders passed during pendency of second are not binding.
Yes.
But we are conscious.
Madam.
We have conscious.
Why confusion? Sir, we were discussing, now we can say we are discussing that what was the scope of the rejection of your application for steel of the demand. This is really an interim arrangement pending the final adjudication by the tribunal. So the court can definitely make a finding, which is always a prima facie finding or a tentative finding, restricted to a grant of stay of the recovery of the balancer, or should not be a recovery of the balancer. Matter will be decided finally. You go there, work it out, have it done. We simply say we were taking care of it whenever it is done. We don't think so that one line or a two line will create something.
Paragraph 8 mirrors, again mirrors, there is some, yes, you kindly see. There is entirely.
Then I will be relying that you are really attempting to have the review of the judgment.
No, not review mirrors.
Also,
Paragraph 8 mirrors, only one line might not be kindly see. You are also taken pain to see. Be that as it may, mirrors, taking into consideration submission of the Royal Senior Advocate and petitioner deposit 20% of the tax demanded by virtue of assessment order, framed under section 9C of the OIT Act during pendency of the first appeal, in terms of subsection 4 of section 16 of the OIT Act. In order to maintain the balance of convenience, this court directs the petitioner to deposit 30% of the balance tax as reminded in the assessment order before. I have said for 20%. page 40, total tax payable bills is 2 crore 56 lakh bills. And 20% comes to 51 lakh bills. 51 lakh bills. I have paid 3.50, so total balance bills comes to 48. So 20% comes to 48 lakhs bills. About 48 lakhs. And you also may direct I will pay bills. If you also directly 30%, it comes to bills again 70 something. So I leave on to your also bills. Your lordship in the last paper asked how much you will pay. And Mr.
Your lordship,
replied,
great respect to
little more, little more.
Great respect to
That is
one senior. There should not be
any day it will come bills.
There
Any
should
day it
not,
will come.
there should not be any out of doubt so far as the 20% is concerned. If the first appellate authority could have accepted those C forms and allowed the appeal, because pursuant to the direction of Honorable Court, this Honorable Court,
Sir, I am reminded of a judgment of the Ramchandra Singh versus Savitri Devi, reported in 2004, volume 12, SCC page 7. The Supreme Court has deprecated what should be the modification, what should be the clarification, everything has been done. So we are stuck up with that. Mr. Sahu, we can't.
Your lordship, only by kindly record minutes.
In terms of
In terms of only my lord's order my kindly in terms of 16.4 read with your lordship's order. That's all. I am not paying for anything more because I will be complying my lord's order because only little clarification. Because I will repeat reiterating because
No.
your lordship have mentioned 16.4.
Yes.
Only and order of this court because in WPC of such. That is that's a matter of fact. It's a matter of record minutes. Article 215 minutes. If there will be a wrong recording minutes, the record will go minutes. That is how to rectify the record, set it right minutes. I give my humble prayer minutes. I don't say most. Let it be everything with there minutes. Let everything. Your also direction by 30% be there. Everything now I say there.
No.
16 section 16.4 along with minutes your lordship's order. And lastly, as your lordship says, the observation will not influence the pending minutes appeals before the appeal. Only this, I am not asking anything more. And those are usual directions of lordship always make those in each and every case. I believe I am not telling my lordship with much of argument, except I know at this stage. Because I was preempted virtually because your lordship asked how much will pay. And your lordship have also written in the order, not argued much. But I am on live stream, my lordship find out because the order of this honorable page for lordship belongs. And because the findings at page 77, that the appeal admitted matter in order, those are also there placable. But I have not done that. And if your lordship will see, the findings of the first authority are completely, or the own saying it's contrary to the own record belongs. But I am not arguing because I cannot argue also. No, the merit. That is left to the appeal of the side. Only this much, one line only. But I will humble prayer in one line, and that will certainly be ask your lordship's consent. %30% I will pay below. Everything I will comply. Only one line your lordship and your lordship's order only. But I am not asking anything from my side. And that is only intended for rectification of not correcting fact notes. After the word 16.4, that observation you also what you said, that it will not influence your the operator. Otherwise, not.
What is very clear. That is what is very clear, sir. It's called.
I leave it to logic concept.
Weekly list item number 1.
Yes, I will. I have a few submissions here. Here after the order dated 26/24. Yes, where is the order dated 27/6/24? And actually. No. Yes, and then we have the 7/6/2024 order. That is the original, is the order in original. Passed by the assessing officer. Yes, ma'am. That is passed by the. You have an appeal. My lord, those are closed for appeal. My lords, I have those are closed for appeal. Sir, here where actually the person who have been assessed after the notice has been issued, assessment after his death. So it is a deceased person has been assessed. Even a show cause was issued against a dead person? Yes. Or he was alive? No, he was not alive. After that, sir. He order said.
Petitioner died in the year 2018.
Okay.
The show was issued in the year 2020 and OIO issued in the year 2024. So ultimately that connected.
No, what is your AD? You have stated in your adjudication order, come to hearing for. Here. Page 70.
Whom you have given an opportunity to defend.
You have stated that 10 number. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Yes. 10 opportunities you have given. Where is the AD? What is that AD say? Had the person dead,
Yes.
then the postal AD should have shown that deceased.
But his son appeared in that matter in the previous case.
Where is it?
There is
Page 16.
and communicated to the notice, but the noticee did not turn up for further personal hearing. That means he never appeared. That is your own finding at page 17.
And in the
Personal hearing. Sir, this is your finding, sir. Please read five paragraphs.
the show cause notice, no one appeared. That's
Sir, when you are hearing on the basis of the show cause, so if there was no personal hearing given, then you proceeded. But there is a contradiction, 4.1 and 5.
yes.
Noticee did not turn up, but son represented.
And then said 4.3, the noticee submitted. From where he came. And if he came, whether you were conscious or you were in your sense, or you become unconscious.
Lordship, item 19 of
10 and notice.
Item 11.
On this matter of
It was a widow domestic help loan. The widow domestic help loan.
What?
A domestic help. She's working, not a widow. So the husband-in-law was some income tax dues with his. Now, the husband-in-law, he expired on 5th of December 2020.
Husband was a SSC.
No. What has happened for his
And the
medical
wife is
condition?
a domestic help.
Plus, your lordship need not view the husband at that level. He had to sell some landed property along with his brother to meet his medical emergencies, and ultimately he expired on 5th of December 2020. That's Annexure 1. Subsequently, my lord, even though the
Why you are not taking that into account? The money has gone for his treatment, and ultimately,
ultimately he expired, my lord, because he was having multiple organ defects, my lord, and he expired.
in a pragmatic view,
Yes, madam. Ashiji died on 5th December 2020. The notice was issued on 27 March 2023.
Much after
And
that.
department has been intimated by the legal head of the assessee on 26 May 2023. Madam. So it was not the knowledge of the department when the notice was issued. Madam.
And ultimately, the order law is
Whether the proceedings may be initiated in accordance with the law, the legal years of the decision. That was section 159 of the information.
This is 148 states.
140.
148 states. That is what we are thinking.
But he has already made 148 deep. We have still chance to consider. We want to proceed with our accept the ground level factual scenario.
A similar matter came up before this honorable court, and it was later confirmed, my lord. Your lordship had quashed that order. It was a 263 order. It was quashed by your lordships, and subsequently the matter was carried to the honorable Supreme Court. The Supreme Court affirmed that order, my lord, on merits. I've also enclosed the Supreme Court.
What merit?
We find no merit in the petition. Hence,
Oh, that is the SLP is.
no, it's not. Your lordship may kindly. Your lord, no, it's not a simple dismissal of the SLP.
On merit as well, when you are talking about, it is,
as well as on merit.
that's why I'm saying, read at the Humayuddin judgment.
But I'd only simply say, my lord, my only a submission would be that
Anyhow,
this judgment of your, this order of your lordship stands. This was a
Similar footing.
similar footing. It
notice
was
was issued when he was dead.
sorry, no? Yes, notice was issued subsequently. 2020 was the date of death.
No,
Whose favor?
Sorry,
Whose name?
the late husband's name. No? The order is also in the name of late husband's.
Yes.
I've made a corrected copy for your lordship.
Yeah. You are corrected. It's back, give it back.
Separate. Item number 12.
And Supreme Court order people.
Supreme Court order.
Only one, give one copy only. Oh, that is, there, no.
And your lordship the corrected copy.
Corrected copy.
Well,
Item 12.
consolidated order multiple use.
Yes.
Item 13.
I request some additional file and additional affidavit regarding this.
Yeah, the counter for the next up says for the we to buy.
Not service.
Why you are not serving a copy, sir? Record his name, the copy of the reputation has not been served upon.
Also, kindly turn to your page 25 years. My attachment 1 years. My credit ledger has been blocked bills by the official bills. People are not able to see bills.
You just turn it off.
Single soap is for multiple uses.
Yes, ma'am.
Yes. 30.
Item 30.
Yes. Sub item. Who is appearing?
Item 3, my lord,
Yes. Give your memo of appearances. Give your memo of appearances.
Corrected copy or name.
Yes.
My
Yes.
item 31.
My lord, the last date of filing of appeal is to follow Sunday. Appeal filed on Monday. Next. Appeal was rejected on the ground of
Under the Limitation Act.
Section 4 of the Limitation Act.
Yes, if it is closed, then on the next day it has to be. What is the difficulty?
Yes, sir. Yes, sir.
Appeal rejected.
For that month, he has to file an explanation. So, this has been issued.
No, this is
That month, that is condonable period of 1 month. On the last day of the condonable period, that is your holiday. 3 months gone. 1 month, that is the condonable.
No, sir, I will hear. I will hear. If it is within the normal period of limitation, if the last day of the limitation falls within that particular holiday or on a holiday, then on the first reopening day you can. But condonable period, I have doubts. I have to ponder upon an issue. Next week, keep this matter differently. Brother, I have doubts. I have doubts.
So the month. I leave it to you, Lordship. I am not. I leave it to you, Lordship.
No, I have doubts. I have not, but it's stuck in my mind. I have to make some research on that. I will
apply to this or not. Limitation of the procedural forum.
No, it's a principles. It's a principles which is borrowed. That we can do.
To some extent, general concept.
Yes.
31.
Skip it.
Next week.
Next.
Next week.
Next week.
Yes, ma'am. Item 32.
Yes.
Item 33.
Matter about what we call it on Monday. What we call it on Monday, it may take some time.
Next week.
Ma'am. Item 34.
So disposed of. Sub item also?
All these submitted.
All.
Yes.
Mr. Vishnu, which you gave a list, does it include this? No.
Item 35.
35 is also 7340.
Yes.
36.
Yes.
Item 37.
Please, my lords. My lords, the issue is same. My lords heard it in the last week. My lords, the period of assessment is different in this case, my lords, and there is no difficulty of filing 2 or 3 petitions like the last petition, my lords. The issue was same that show cause and orders were passed identically, my lords, without any findings, my lords.
Not 100% same as like as that case. Here the reasons is there, not in many words, but reasons is there and the different terms focus.
Come on the next week.
Your Lordship.
My lords.
We have hardly 2 minutes time left.
Your Lordship.
Item 38.
Oh. If we do not take up at least one matter, we will be blamed. Yes, 39.
39.
We have to take one matter at least. Otherwise, they will be blaming.
39.
For lawyer, 1 matter. So,
I have lifted the entire NDQ in the meantime, but they have rejected my application that you have not lifted the NDQ. Section book IDC, page 11, translated copy. The only thing is that any due outstanding. Due is no outstanding. I have lifted the entire NDQ in the meantime. I have documents for that.
So what?
I'll very formally take it, sir.
Take
So let me
instructions.
take one small frame. 31st March is coming. Let this not
Yes.
insist me to renew it.
Huh?
Let them not insist because I am surrendering it. 31st of March is the last day.
Yes, Mr. Rob, he wanted to surrender, so don't renew.
The license, I'll obtain instruction.
Then come on Monday, take instruction.
Yes.
He is apprehending that 31st March is coming, you will again renew his license and demands full, which he does not want. He want to surrender. He want to surrender. That is what is apprehension and which is genuine apprehension.
Do not renew it before the next.
That is what is there. He says that don't renew my license.
I'll do that.
So we are keeping it on 30th Monday. Take instruction. Yes.
Item 40.
I am seeking a direction to complete the shifting process within the stipulated period. In the meantime, the collector has rejected my shifting application. Permitted to withdraw the petition with the liberty to file it. That's application.
It is submitted by the council appearing for the petitioner that
I'm
1 minute is left.
mobilizing.
We have to hold 305 the
Yes, yes,
report
but-
there. That's why we are thinking. Will you
Yes,
complete within 1 minute?
yes.
Yes.
Not here. The regular report has been given and to submit explanation before the superintendent site. I submitted explanation before superintendent, but collector has passed over.
I'll take instructions.
Under Annex 5, yes, passed
Take
over.
instruction, next week it will be taken off first. Do one thing, next week, I'm doing it, next week, excise matter should come first and the taxation matter would come second. So that at least they get an opportunity. Do it in alternative weeks like this. 1 week the tax matter first, excise second. Next week the excise first. the next week-
Item 61 can permit to withdraw.
Which one?
61 items.
61. Who is appearing?
Same step.
61?
On 61.
I want to withdraw. 61, who is appearing?
TSA is appearing, but it's withdrawal, then no.
Who is appearing?
Yes, it is for withdrawal memos.
So the item 42 is covered.
No entry.
180.
180 ml. 42 is appearing.
47 also.
Oh, just one by one. Huh?
It's 42.
Yes, 180.
180.
Yes,
47.
180.
180.
Item number is written for.
No,
Yes, item number.
Nikhil,
192. Yes. Item number.
Nikhil,
47.